Thank you, students, for tuning in to our channel, African Dignity. Let us continue with our lesson 7 of your study guide, which deals with privilege. I will just go through it again, and because I want to make sure that everybody understands the concept of privilege when it comes to evidence. Now, first of all, what do you mean by privilege? So, privilege can be described as a personal right. It is a personal right to refuse to disclose useful and admissible evidence. Let's just put it like that. We know that there are many types of privilege, including professional privilege and also privilege against self-incrimination. So, and it is important that you cannot force people to give evidence if that evidence is going to incriminate them. So as a lawyer, you will be wary of those exceptions when it comes to evidence and privilege. So I will advise you guys to read the book of Zefret and Pies, the third edition, which is the South African Law of Evidence, the third edition, at page 621. Start from page 621, where you will get the introduction to privilege, what is meant by privilege, and then you will also see the types of privilege. One other important aspect is that you need to remember that there are two sets of witnesses that are supposed to give evidence. So at the end of this lecture or this lesson, you will need to be able to distinguish between the different forms of privilege and also apply the requirements for each type. And also you must be able to differentiate between a competent witness, what is called a competent witness, and a compellable witness. And also be able to know that not all witnesses are compellable, right? A competent witness is a witness that is asked by your client or asked by the state in the case of a criminal case to come and give evidence. But a compellable witness is a witness who is reluctant to give evidence but is forced by things like how we discussed section 205 of the criminal procedure, where you will compel, the court may compel the witness to come and give evidence. We've seen recently in the case of Advocate Mkhwebane versus the South African Parliament. There is an inquiry going on there now, and Advocate Madonsela, who was the predecessor to Advocate Mkhwebane as a public attorney, actually refused to come and give evidence. But ultimately, she was compelled to come and give it, and she did. So those are the Those are the other examples of compellable witness, right? There is another striking case of the United States versus Nixon. Nixon was the president of America, I think around the 70s, just after the Vietnam War. There was a president called Nixon. He was not impeached, but he was asked to resign because he had committed what is called in America as felony. Felony in America means serious crimes. He is alleged to have instructed his people to go and break into his opponents' offices in order to get information so that they could win elections. So it will go there. I asked people to go there, and there was an inquiry called the Watergate. And after that inquiry, when the president had resigned, then everybody said now he has exposed himself, he is no longer immune to prosecution like how it is happening now with Trump. But lucky for him, for President Nixon at that time, the Chief Justice was a man called Warren Burger. Right? Warren Burger said the exceptions to demand for evidence cannot be taken lightly because they are in derogation of the search for the truth. Meaning, yes, the president could be exempted from coming to give evidence because of privilege, right? In America, there's something called Fifth Amendment. People just say, when they are asked questions, they say, I will invoke my Fifth Amendment. That means a right not to implicate yourself. In our law, I've said it's section 35 of the Constitution. In section 35 of the Constitution, that gives you the right not to be silent, the right to silence. So in America, it is called the Fifth Amendment. So he was then given that right. So it is important for us now in our class to be able to know all these types of privileges, like I've said, including there's something called husband-wife or privilege for married couples, that married couples are not compellable to go and give evidence against their spouses, right? But also, you will think that it is unfair in a case where today you will hear of parents abusing their children, sexually abusing their children. Now, do you think it is fair for one of the parents to hide behind privilege when she or he is supposed to give evidence against her spouse? Then it becomes a bit of a problem, because in my world, if you refuse, that means you become complicit to that crime. So it's a catch-22 situation. You can hide behind it, but also you may expose you to some other unwanted attacks from the public or from the very child who was maybe sexually abused by a parent. So we need to be careful when dealing with this. Also, there is privilege, what is called the state privilege. There was a case I think it was the EFF versus Pravin Namjadas Godan. That case, it was him and others. So in that case, they wanted the state to produce evidence that showed that there was a rogue unit that was employed by Godan when he was SARS commissioner to use what we call covert means to source out information about people who were dodging taxes, who were evading tax. There was a full scale of mafia gangs who would do business in South Africa but refuse to pay tax. So there was something called the rogue unit. And the public protector then, who was involved in that investigation, because it was a complaint that was brought to the public protector. So although that rogue unit was what is known as a covert operation. So if a covert operation, that means it's classified. Now somebody came and alerted the public protector that that rogue unit was no longer classified, which means it was declassified. So once information is declassified, that means it is ready for public consumption. So there was this to and fro where the public protector was asking the person who was in charge of the rogue unit, who at that time it was Mr. Lochenberg. And Lochenberg refused and said he doesn't know that the matter has been declassified. But he was not telling the truth, because recently in the commission that we had, that is going on currently at the portfolio committee, it has been proved that in fact that information was wrong. The rogue unit covert operation was actually declassified in 2014, and it had a signature of the commissioner then, someone Advocate Khade. He's the one who signed for that covert operation to be declassified. And because the complaint was that that covert operation was using taxpayers' money is illegal. They would not use paper trail. They would pay monies to people, cash, so that they save those people from reprisal from the mafia. So that was the complaint, and it has now been proved that the information that was given to the public protector was actually wrong. That covert operation of the rogue unit was in fact illegal, and hence it was declassified. Yes, it existed, it was classified when it existed, but people complained and said it's a waste of money, it's unnecessary. Then it was declassified, and recommendations were made that it should stop. But apparently it continued, hence there was this complaint. So evidence which is classified is subject to privilege. You cannot say you want that you want to compel people to lead that evidence or to come and be witnesses to give classified information, because the problem with classified information, it may cause harm to a number of people or harm the state. It may result in a war. Imagine in Saudi Arabia, there was a guy who was killed in Israel. This guy was classified as the enemy of the state because he was a journalist, and he was born in Saudi Arabia, but he had an American citizenship, I think by naturalization. So he was then declared as enemy of Saudi Arabia, and a covert operation ensued, and he was killed by the state agencies of Saudi Arabia in Israel, apparently. Now, can the people who were seen on CCTV going into that office, which was I think it was the diplomatic office of Saudi Arabia, that is where this guy went in, and he was never seen afterwards. So that's another example of circumstantial evidence. We are going to deal with circumstantial evidence to say the guy was seen entering the ambassador house of Saudi Arabia, and there is no evidence of in their cameras, the CCTV, where he was seen going out. So the last sightings of him was when he entered that diplomatic office of Saudi Arabia, and people were seen carrying suitcases. So there is a possibility that he was dismembered and put in suitcases, but that evidence is still lingers. Nobody has come forward to confirm it. It's still circumstantial evidence. Now, privilege. The people who committed this crime will be privileged, will be allowed not to come and divulge that information, because it might cause animosity between the state of Israel, Saudi Arabia, and the state of America. It's an embarrassment. It was done recklessly, but still nobody is allowed to bring that evidence so that we will know exactly what happens to Mr. Khashoggi. I think what his name is. And also, privilege also means that relevant evidence is excluded, not because there is better evidence that the court has found, but because of the need to protect a higher value which has been given primacy. That means it is primarily important that a particular person has to be protected, because if evidence is heard in a public place like the court, it might jeopardize the security of the state or the security of that individual. You must remember that the life of a human being is paramount. Hence, the Mukwanyana case, that killing another person is not is unconstitutional. So, if a court does anything that would jeopardize the safety of that person and renders that person to be exposed to death, then that will be regarded as unconstitutional. Once we talk of privilege against self-incrimination, the cases are relevant to that will be the case of Luane, State versus Luane. The citation is 1966, volume 2 SA at page 433, and it's a Court of Appeal case, right? It's very important. Also, the case of Maunye, I've given you that case. Also, the very important section in the Constitution is Section 35, subsection 1 of the Constitution, and also you may look also at Section 35, subsection 3, right? Those are the very important sections, including Section 203 of criminal procedure. You can look at 213, 217, 219 of the criminal procedure. They will tell you about the need to protect somebody against self-incrimination. In support of privilege, that is state privilege, you can read section 202 of the Criminal Procedure Act and also read section 42 of the Civil Proceedings Evidence Act of this 45 of 1988. You can read that as well. It will tell you when the state can withhold or exclude relevant and admissible evidence in order to protect an intelligence operative or a minister. Like I've told you that ministers, when they are sworn in to take office, they also swear that they would not divulge sensitive information that they have been privy to as government ministers. Another important aspect that you know is where information is held by the state in a criminal case, and you need to know as to when will that information be ready to be given to the other side, that means to the accused, in order to prepare for his defense. And the answer to that is that when the prosecutor has declared that investigations have been done and closed, that's the only time then the defense may be finished with statements so that they can prepare for their defense. That would be done in pre-trial. So that is very important as well. Okay. Again, I cannot overemphasize the fact that when you are given a question on hearsay evidence, that is our lesson 8, hearsay evidence. 7 was privilege and 8 is hearsay evidence. I cannot overemphasize the fact that when you are given a question on hearsay evidence, the most important thing for you to do is to first define hearsay evidence. And when you define evidence, don't summarize, don't take corners. You must define it as it appears in the act, right? So you will say, in terms of the Law of Evidence Amendment Act 45 of 1988, hearsay evidence is evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. If you do that, you've got your full mark and nobody can fault you. Also, remember that when you talk of hearsay evidence, remember that hearsay evidence in bail application is allowed. So you cannot say no, hearsay evidence is not allowed because advocate said hearsay evidence is inadmissible. Yet it is inadmissible. But when it comes to hearsay evidence by an IO, for instance, in a bail application, that evidence will be admitted and there's nothing wrong with it. Okay? And the cases that you must read is the case of S. Ndlovu, 2002, volume 2, SACR, at page 325. It's a Supreme Court of Appeal case. You must read that case. It will tell you about hearsay evidence. I don't think there's there's some more that we need to know. But I want us to deal with circumstantial evidence. You must deal with circumstances. It's important because I will ask Ranide to give you a question, or I will prepare a question on circumstantial evidence, and I will give you 3 cases that you will have to support your answers when you are dealing with circumstantial evidence. Students, when you're dealing with circumstantial evidence, there is 2 things that you need to be clear with. First of all, you must be able to distinguish between circumstantial evidence and direct evidence, right? Direct evidence is where a person would say, I saw Norma Pelo stabbing her husband with a knife. She stabbed him 5 times on the back and 1 time on the face, right? So it's direct evidence. But even then, you cannot just take that evidence as a trier of evidence. You cannot just take it at face value and say, because he says, I saw her stabbing her husband. You can't believe in that. It has to be tested. Tested by the court from the person who's giving it. Because people can look at a scene or at an incident and come with different explanations. Some people are colorblind. If you ask them what shirt was he wearing, what shirt was the husband wearing, they might say the shirt was white, and yet another person say it was off-white or it was cream. So all those mistakes. And a person, you might ask questions like, how far were you when you saw Norma Pelo stabbing her husband? And the person will say, I was 100 meters away. And if you ask her, then if you ask the witness to say, can you show the court what do you think is 100 meters? If just show it here in court, make measurements here in court and tell us with the distance that is in your observation that equals to 100 meters. How long is that distance? By way of illustration, just illustrate to the court how far is 100 meters from where you stand. And then the witness might say, from where I'm standing to the door or to the parking lot, and only to find that the person is not sure of 100 meters. Then that's where the doubt starts, that a person doesn't know and cannot distinguish between 100 meters and 200 meters and 300 meters. He might give evidence to say it's 100 meters, and when you take a tape measure to measure what he said, only to find that it's less than 100 or it's even more than 100, then again the trier of that evidence now is in doubt if the person actually knows exactly what he saw, if he saw what he saw, because he could have been far and he didn't see the person stabbing, but he thinks he saw. So the trier has to make what is called inference. And by doing that, by asking other questions, things like she stabbed her, and where did, how far from the perpetrator did the deceased fall? He might give different explanation as well in as far as distance, right? And sometimes we'll ask, did he fall on his back, on his side, or on his stomach? Things like that. He might, because an incident like that is shocking, so a person cannot look at it and analyze. Sometimes when people see things happening in front of their eyes, they close their eyes. They are shocked, they close their eyes, sometimes they run away. So if somebody gives you direct evidence, you need to interrogate that evidence, or you need to ask clarifying questions around that evidence. Okay, now let's come to another set of evidence now, the gist of our lessons now, which is circumstantial evidence. Circumstantial evidence is an evidence where a person says, I saw the accused coming out of her house carrying a knife filled with blood. The question is, did you see the accused stabbing her husband? And the person said, no, I did not see it, but I saw her coming out with a blood-stained knife. And now the trial has to make assumptions now to say, well, if she came out of the house with a knife, then the deduction is that she must be the one who killed the husband. But anything is possible. He might have found, there are other inferences, that's the other scenarios to say, because with circumstantial evidence, there must be other possible scenarios. I will give you an example of a case. I think I will give you 3 cases. One happened in Bizana, the other one happened in Nottingham Road, in the Natal Midlands. Right, I will give you those 2 cases, and the other one is a well-known case of R versus Blom. You know about it, you must have read it, but I'm going to give you these other 2 cases where circumstantial evidence was given and people were convicted, but on appeal, those convictions were set aside. Support your answer when dealing with circumstantial evidence with 3 cases. Don't forget these cases. The cases will be Shaw versus State, and it is a reportable case. This case happened in 2011. It is ZAKZPHC, which means it's a South African case held in Pietermaritzburg High Court, 32 AR 342 of 10, right? It was held on August 2011. It's State versus Shaw. It was on appeal, right? In that case, you must read it. It's about circumstantial evidence. Shaw was convicted and sentenced to 15 years, but on appeal, that sentence was set aside. In his case, they had been staying in a farm somewhere in the Midlands, and they were staying in a farmhouse. There was no network in the farmhouse. So both of them, anyone would say if you wanted to call or to send messages, they will go to a place which is quite a distance from their farmhouse. You would have to drive to get into this place. It was sort of a level higher than where they were. So they would go to that place, some kind of a hill, and there they would then get signal. Once they've got signal, they would send messages. So on this day, Shaw went to this place for the signal, and when he came back, he found his wife dead with 1 bullet on the thigh, with 1 bullet wound on the thigh, and she found even the place was not disturbed for anyone to think that it was maybe thieves or burglars. So he then, after being shocked, when he tried to resuscitate and saw that this lady was, although she was not dead as yet, he then went away to the same place of signal and called the relatives of his wife, and also called for an ambulance and police. So when he came back, his brother-in-law and some relatives of the wife and the police were on the way. They met on the way. He tried to greet them, and they just refused. They didn't want to respond to his greetings, and he thought then trouble had started. So what transpired was that they were accusing him of having killed. They said, well, no, we know you had problems with her, so it's obvious that you killed her. Now you're just calling us to come and, they actually fought with her. And then he was arrested for murder, and he was convicted. You can read the case to get the gist of the story. But on appeal, then it was found that there could be other possibilities. The possibility that intruders came and tried to rob her, and maybe she might have refused, and she was killed. Another possibility was that she may have committed suicide. So the third possibility was that she killed herself. She killed herself, or the other third possibility was that she might have been killed by her husband. So there were three possibilities. So that's what happened in circumstantial evidence. There must be other possibilities or other inferences. In the case of Nkobungu versus State, it's a case that happened in Bizana. Mr. Nkobungu was one of the guys who had acted as a principal in a school. They both, the two guys acted as principals in the school, and the district manager, who is now the victim in this case, advertised the post, and Mr. Nkobungu was not successful. The other guy who had also acted in that school was successful, and Mr. Nkobungu is reported to have been very angry because he had worked in the school and he wanted this post. And then after a while, after this guy had been appointed, then the district manager was found killed. He was shot. Nobody knew who shot him. So then, because of that feud where Mr. Nkobungu was angry and he had acted in this position, so there was suspicion that he may be the one who killed the district manager. He was arrested, he was convicted, he appealed the case, and he was successful. Another case is R versus Blom. It's a 1939 AD 188 at page 202 and page 203. You must know this case. It's an old case. It was not like the other two cases that I've given to you. Go and read all three of them and tell them, and when you answer that question, you will state the principle in all three of them and what transpired. That is circumstantial evidence. I think you need to end it there before you are confused. Thank you.